It isn't contentious. Yes, it is contentious. No, it isn't. Yes, it is. And how can you tell unless you hear the main application to decide what are the issues in the application and really what's contentious? So I say in those situations, one of the functions of a judge hearing a case on its merits is to rule on evidentiary issues. And therefore, I think that the proper place to argue evidentiary issues is before the tribunal, whose job it is to rule on it, just like a trial judge at a trial deals with evidentiary issues. And the argument is, but if the judge reads it, then, the damage is already done. But the same thing happens at a trial. You call a witness, there's an argument, admissibility. The judge always says, well, I'll reserve that to the end of the trial and hear the evidence. It happens all the time. But nonetheless, he may exclude that witness, but he has to hear the evidence first. And it seems to me that's the proper way of approaching it. Now, in Nirali and Kumar, which I just heard a couple of weeks ago, the reason I did it in that case was it was so clear that it wasn't even arguable. There was absolutely outrageous, scandalous, and irrelevant material in the affidavit, which was just put in there to embarrass the other side. And so I held it wasn't arguable. It didn't need to consider what the case was about in the merits. It was absolutely, unquestionably inadmissible and scandalous. And it was on that basis that I struck it out, drawing a distinction between that and the other ones. And then I cite the case of Ree McDonald and Peters and Halton, which were examples, and AG Canada and Bank of Montreal are all examples where judges hearing applications are ruling on the compliance with the rules and the admissibility of affidavit evidence as to whether it contains scandalous material, irrelevant material, hearsay, and what have you. There's the one case of Peters, Quinlan District Court judge heard a motion to attack an affidavit where he wasn't going to be the hearing judge, so that's a little bit of an exception. Now, number 18, motions to strike out parts of pleading. This is a case that was Lido Industry and X-Bar, which was raised also by Derry Millar. Now, it seems to me that the Lido and X-Bar case is as interesting on master's jurisdiction as it is on the question of whether you can counterclaim for abuse of process. Because there, Master Pepiot did what masters have been doing for a long time, and that is looking at a plea, and if it contains something that the law says is absolutely untenable, you can't do it, striking it out. Untenable pleas is a concept that was clearly within the old rules, and there are lots of master's orders and appeals on that subject. Mr. Justice Callahan said, oh no, this isn't striking out some pleading because it's offensive, but striking out the whole cause of action of the counterclaim, and therefore the master ought not to have done that. And so he argued, you could. I think he got so caught up in the jurisdictional issue that he then forgot to focus closely on the merits as to whether or not it was a proper counterclaim or not. And that may explain why Lido is inconsistent with the other cases. And query whether the doors are opening or narrowing, sometimes you just have to face it, the case is wrong. Now, it's a divisional court case, but it's a single judge of the divisional court, and this would be a perfect example of a situation where, you may want to take this case on. I think this case is wrong on the main issue as to whether or not it's permissible to counterclaim for the abuse of process in an ordinary action. And I think the other cases that were cited by Derry Millar are preferable. So don't be totally intimidated by Lido. But it does show the difficulty in knowing whether or not your motion is a motion to strike out a pleading or to strike out, which a master can do, or is it a motion to attack the action under Rule 21. I would highlight this, that Rule 21 says the action is an abuse of process. Rule 25 talks about the pleading being an abuse of process. And I think one has to deal with the words of the pleading, and compliance with the rules of pleading, and the other has to do with whether in law you can assert a cause of action. But if the law is clear, if there's a Supreme Court of Canada judgment which says you can't do this, and a pleading seeks to do it, and you now want to attack that pleading as containing an untenable plea. Is that a master's motion under 2511, or is it a judge's motion under 21? It's very difficult to say with certainty. I think there is jurisdiction in that situation. In other words, if it's arguable, then you're striking out an action. If it's not arguable, if it's clear and it asserts an untenable plea, then it's a pleadings motion. But the mere fact that you've put in your notice of motion that you're relying on Rule 2511 doesn't mean that that's really what you're doing. So you have to look very carefully and closely at what is being asked for in reality, rather than what the notice of motion says or what rule is relied upon in the notice of motion. And on occasion, I have sent 2511 motions to motions court because in reality they are Rule 21 motions to dismiss an action as not disclosing a reasonable cause of action. So sometimes it's very difficult to know which one it is. And lastly, I'd just like to make the point that Vayman and Yates is a very important case, number 19, holding. Now it's interesting. A master cannot hear a motion to strike out a claim as not disclosing a cause of action. That's Rule 21. But if you're a plaintiff and you want to put a cause of action into your claim, then the master can consider whether or not what you seek to put in sets up a reasonable cause of action. And if he doesn't think it does, or it's an untenable plea, he has the jurisdiction to disallow the proposed amendment, even though if he had put it in originally, he couldn't strike it out under Rule 21. That's what Vayman and Yates says. So it depends from which direction you're coming at the problem to determine whether or not the master's jurisdiction. It doesn't make sense. It is illogical. But there is a tendency now on the part of the judges, in my view, to give the masters as much jurisdiction under the rules as they possibly can, I think to lighten their load in weekly court, which is a horrendous load. That's just a personal opinion. But I think that may be the explanation of Vayman and Yates. Thank you very much.
You will all find my paper. It's one of the loose ones that's in the front of your binder. The answer to the question that's posed by the title can be found in the 3 B's of setting aside default judgments, and that is to be quick, to be candid, and to be complete. And I've given you on page 1 of the paper the 3 things that you must show when you move to set aside a default judgment. The principles are well established by the cases. The pre-January 1, 1985 cases still apply. The Rule 526 experience has been applied to motions under the current Rule 19, and in the indented portion on page 1 in paragraphs A, B, and C, I've set out the 3 things that you have to demonstrate. But before you resort to the legal approach, let me suggest, as I do in the paper, that you first consider the practical approach, and that involves picking up the telephone and calling the plaintiff's lawyer. Courts have a real preference to have the action decided on the merits and to give the defendant his day in court and to have it decided at trial and not by default. Most plaintiffs' lawyers understand this, and they're about as anxious as you are of not wasting their client's time as you don't want to waste your client's time. And so an offer on the telephone to pay a reasonable sum for the costs thrown away, and if necessary, maybe a commitment to an early discovery date and prompt production of your documents, very often produces a consent order out of the plaintiff's lawyer. And so in something under a half an hour of your time, you can get your defense in and get on with it. Now, every once in a while, you're going to be faced with a case where you do have to go to court, either because of the nature of the case or because you have run into one of those few jerks that are still out there who really think they've got you over a barrel because they signed or got a default judgment on the 21st or 31st day after they served the statement of claim. And so if you do have to go to court to get some help, Starting at page 2, I've set out briefly what you ought to think about in terms of complying with the 3 Bs. In terms of being quick, that means you get your motion launched quickly. Sometimes you can't get it launched quickly because, for example, the court can't find the court file. One of the things you want to do is plow through the paper that is in the court file to see if you got any technical grounds to be able to set aside the judgment. And if it takes them a couple of weeks to find you the file, put in your affidavit material why it was that the motion to set aside the judgment got launched 2 or 3 or 4 weeks after your client came to see you. In terms of being candid, your affidavit should set out the real reason why the default occurred. And if the real reason why the default occurred was because somebody in your office, usually you rather than your secretary, muffed it, don't be shy about saying so. It's absolutely amazing what a good lawyer and a good judge or master will do with the truth, no matter how embarrassing you think it might be. And so your affidavit shouldn't be either incomplete or shy about disclosing the true reason why you didn't get the defense in on time. Thirdly is the question of being complete. Master Sandler talked earlier this morning about questions of res judicata. If you've got a bunch of defenses that you think will meet the third condition that you have to show to get the default judgment set aside, put them all in your affidavit. You're going to get one bite at that apple. If you go in with some and you fail, barring something bizarre, you can't come back a second time and try out the rest of them. If there is some really substantial defect in the technical compliance of the plaintiff with the conditions that entitle him to sign judgment, by all means, put it in your affidavit material. But I think it's the very brave and probably very foolish lawyer who only goes in with just those technical defenses as in material if he really does have some additional defenses that are on the merits. I think you'll find, in that respect, that the old adage about not wanting to let the plaintiff have a chance at either cross-examining your client or cross-examining on all of your defenses at an early stage really doesn't apply anymore. With the power to cross-examine on discovery, you really give up very little by letting the plaintiff have a crack at those issues at this early stage. The only real disadvantage you're at is that the cross-examination of your client may take place without you having had the benefit of the plaintiff's production of documents, which you would have had if it were happening at discovery. And that leads to the problem of whose affidavit do you file on the motion. I've given you the reference to Chittle and Rothbard and what Mr. Justice Anderson has to say about that. The best evidence rule applies to motions. You should be giving the court the best evidence. Using just the lawyer's affidavit to say that there's a good defense on the merits really doesn't accomplish very much unless somebody has deposed to the truth of the underlying facts, in which event it's really for the court to decide whether you've raised a triable issue on those facts. As a general rule, though, in terms of the affidavit material, it really should be your client's. There may be some exceptions if the substantive defense you're seeking to raise really is nothing more than the provisions of 1 or 2 clauses in some agreement between the parties. You might be able to get away with just your affidavit, but that's an individual decision that you've got to make in each individual case. The old cases, some of them, talk about being able to set aside a judgment as of right where, for example, the plaintiff has signed judgment for a grossly excessive amount. And Master Pepiot in the CIBC case, which I've given you a reference to, makes the very useful observation that Rule 1909 does add something to what was not there in Rule 526, and that is giving the court the power to vary a judgment without having to set it aside. And I think what you're going to find is that in cases where your sole defense is that the plaintiff signed a judgment for far too large an amount because he overlooked some payment on account your client had made, you're more likely to end up with an order that varies and reduces the amount of the judgment rather than an order that sets aside the judgment and lets you get on and file a defense. Lastly is the question of posting security as a term for having the judgment set aside. And here you've got to try and face reality. If you're moving 3 and 4 and 5 years after the judgment, or if you're moving in the face of evidence that your client is about to sell his house tomorrow, you better think about the fact that you may have to put up some security, and you ought to be prepared to deal with that. If you've got a defense that you think you can make out as being not only a good defense, but one which is very, very likely to succeed, maybe you can avoid having to put up security, because why should your client be in a position, for the sake of having missed a couple of days in getting that defense in, why should he be in any different position he would have been in avoiding a prejudgment execution on his property? But if you've got a defense that may be questionable, that may just get over the hurdle of making out a triable issue, you may find that the court is very desirous of seeing that plaintiff protected. And where you've got that kind of case, I think you have to be practical and you have to be ready to put up the security, because if you approach your motion on the basis of not putting up some form of security in some of these more aberrant cases, then you run the risk that a court will, rightly or wrongly, begin to doubt the genuineness of the defenses that you're seeking to advance, and may conclude, therefore, that you really haven't met the Rule 19 tests. Thank you.
Because we're running out of time, and I think it's very important that the panel proceeds so questions can be dealt with, I'm just going to take a couple of minutes on dealing with exploring the merits of a case before discovery. When is this possible? This starts at lecture notes E15. What I tried to do, and I'm going to simply recommend that you take a look at this material, but what I tried to do was to set out the situations where you can and where you cannot explore the merits of the case before you get to discovery. The first area that it's sometimes permissible to do this on is at the pleadings stage, usually in relation to either amending the pleadings or adding parties. And I'm going to come back to that. But that's the first one. The second one on E17 is a subcategory of pleadings, and that is amending pleadings by withdrawing an admission. Here it is more likely that you will be allowed to explore the merits of the case with the side who's trying to withdraw their admission than amending pleadings generally, because of the test to withdraw an admission as laid down in the Gould and Aris and Antipas cases, which has to do with showing that the proposed amendment withdrawing the admission raises a triable issue. So the very test allows an exploration of the merits. The next heading is motion to set aside a default judgment. And as Ted Kirshner pointed out, one of the things you have to do is show that you have a triable issue. And therefore, you have to put in material on your motion to show that you do have a triable issue. The case there of Mantia Oak and Allen, these are all cases which set out the test. Now, one thing that's uncertain is whether or not you have to show the merits of the case when you're moving to set aside a noting in default. In other words, the plaintiff hasn't yet signed default judgment. He's only noted you in default, but before signing default judgment, you move to set it aside. Now, under the old law, under the old rules, there was a motion, a rule dealing with setting aside default judgments, Rule 529. The rules were silent with respect to motions to set aside noting of pleadings closed. There was nothing on it. The court held that it was sort of inherent that that remedy was there, that a master did have jurisdiction, and two cases, Lopet and Techner and Weider and Williams, which is cited on E18, held that you didn't have to put anything about the merits of the case to set aside noting of pleadings closed. Well, now, Rule 19 is a rule which covers both situations. and it authorizes the court to set aside default judgments and set aside notings in default. The exact same language is to be found in Rule 19 in relation to setting aside a default judgment as it is in relation to setting aside a noting in default. Therefore, it seems to me to follow that if the rule now authorizes both proceedings and that the language is exactly the same, then the same test should be applied to both setting aside noting of default and signing default judgment, and I have held that that is the case. Now, the cases Wilson, Archer, and Sayers in Alberta Court of Appeal said the very same thing, and that is that you have to set out the merits. The things that you have to do to set aside a default judgment are the same as setting aside noting in default. There are two cases in Ontario, both unreported, Bank of Nova Scotia and Gamble, February 1985, which was a local judge of the Supreme Court, and my own decision in Thuringingham and Goodman to the same effect. Now, there's a case, Bank of Montreal and Rich, which is reported, which is a district court judgment after 1985, which went the other way, relying on the old cases of Lopet and Weider. But nobody is looking at Lopet and Weider, looking at the statutory framework that existed at that time and understanding why those cases went the way they did. And now that we have new Rule 19, it refers to both proceedings, the language is the same. How can the result be different if the language is the same? So that's my view on, and my ruling on motions. Now, what has happened several times is people come in, they rely on Weider and Williams and Lopet, they don't put in the merits. I say they have to, they don't know that. So, of course, what I do is either adjourn it or dismiss it without prejudice to a second one, because otherwise you get into res judicata. Because the failure to know what the law is isn't very helpful argument on why you lost the first time and you got to bring a second one. So that's a perfect example of how you're protected against res judicata by applying the principle that was set out in the Lear decision in Saskatchewan, saying the court usually will, but not always, so be careful. Security for cost motions, you can get into the merits of the case because merits are now open for discussion on motions for security for costs, and in cases under the Public Authorities Protection Act and the Libel and Slander Act, the statute itself talks about the plaintiff not having a reasonable claim, so you can explore the merits there. Motions to discharge certificates of pending litigation, the merits are fully open for discussion. And many of the cases that I hear, the big issue on the motion is the merits of the claim, the strength of the plaintiff's case, and the request that you exercise your discretion to discharge the certificate because the plaintiff's case is a loser. And so the merits are fully open for review on that type of motion. Now, injunctions. Atkinson raised the issue in relation to injunctions about whether or not you can cross-examine on the affidavits in support of and contra the injunction on the issue of the financial position of the plaintiff and the financial position of the defendant. I have two cases, both High Court judge, both unreported, which say yes, financial position of the plaintiff you can cross-examine on the value of the undertaking as to damages. In other words, how good is that undertaking? Is it backed up by any assets? What am I going to get if the plaintiff loses and I have to enforce the undertaking? So that's a valid area of inquiry. And the defendant's financial position is explorable on injunction issues in relation to whether damages are an adequate alternative remedy. Both masters' decisions affirmed on appeal, so that answers that question. But generally speaking, you can, of course, in injunctions explore the merits. And I would say it's almost impossible on a motion disputing questions on cross-examination on an injunction to win on any question, because the scope of the issues on an interlocutory injunction are so broad. The merits of the case, the position of the financial positions, plaintiff, defendant, conduct of the parties, balance of convenience. I mean, everything is up for grabs, and that's basically what CIBC and Mullany said about the scope of cross-examination on interlocutory injunctions. Examination of witnesses before trial is a very small point. There, you cannot do that before trial. Consolidation, you can't get into the merits, although an attempt was made to in that case. Summary judgment, of course, you can, because the whole issue on the motion is the merits of the case. Now, I just want to go back to page 1 and highlight one thing. Amendments to pleadings, they are getting easier, not harder, easier, much easier. And the question is the merits open for discussion and review, either on the motion to amend the pleading or on an examination of the parties or witnesses before the motion is heard, usually cross-examination on an affidavit. Now, Vayman and Yates, which I mentioned earlier under my jurisdictional issues, said that the merits of the case can be got into on a motion to amend a pleading, but only the merits as reflected on the draft pleading. There's a difference between the merits as they're set out on the paper and the merits of the underlying evidentiary data, what really exists, what you can actually prove, never mind what you hope to prove. The text of what you hope to prove and what you hope to argue is open for discussion on a motion to amend because Vayman and Yates says so if you can show it's an untenable plea. What is not open for discussion, however, is the actual evidence that you have which can prove the things that you hope to be able to prove. And that's what AHA Imports and Numbered Company holds, that you cannot explore by way of examination of witnesses and cross-examination on affidavits the merits of the facts upon which the plaintiff relies to make his amendment. Now, Seaway Trust and Markle is an important case, I think. I'm sorry to say this because I wrote it, but it's whether or not the situation is different where you're seeking not to amend the pleading, but to add a party. Because under Rule 26, the rule says the court shall allow all amendments unless, and Rule 5 says the court may allow you to add parties. So the argument has always been, well, may means may and shall means shall, and therefore when you're adding parties, the court has a discretion, including to decide to look at the merits of the claim, the actual factual merits. And what I held in Seaway Trust and Markle is no, that is not why may is in Rule 5. It covers other elements. Is it too late? Will there be prejudice? Is it a proper case for joinder? All these other considerations, but not the merits. And the test is the same, and you do not consider the merits of the case, and therefore when an affidavit is put in seeking to add X as a new defendant, you can't start to cross-examine the deponent or others or examine people or put in evidence that in fact there's no evidence to prove the allegation against P, the added defendant, or P seeking to show that the plaintiff hasn't got any evidence to prove the facts to support the alleged cause of action against the proposed added defendant, and the proposed defendant cannot explore the merits on the motion. And the appeal is being argued on the 19th of May. It's a big case involving Seaway Trust and Markle, and it'll be interesting to see what happens. But that's my ruling there. Now, I think the panel starts now, Yvonne.
I guess questions are either to be handed up or just raise your hand. Or any questions to be asked first?
First one is always the hardest.
Where judges may support a case on court by way of security, the master has jurisdiction over the case out where the plaintiff is alleged to security.
Is that to me? Yes. The question is, if a judge orders security for costs to be paid in, presumably on a motion on appeal or something? I mean, how on an application? Oh, in other words, as a term of granting the application, an order for security is ordered to be paid in. Is it security for the costs of the case, or is it security for with respect to damages in the event that the plaintiff loses. In other words, why is the security ordered in the first place? It has to be security for the costs. I would say if the judge ordered security for costs as a term, then a master, is it varying the judge's order? That's the question. And the argument is that, what's the argument in support of why it should now be paid out because of changed circumstances? It's a hard one. I can see a very good argument as to why not, because that wasn't a motion for security for cost the judge heard. He was hearing an application, he made an order, as a term, he required security for costs to be paid in, but as a term of the application, I couldn't have heard the application, therefore it's truly a variation of the judge's order. Probably not. That's off the top of my head, probably not. Does that agree with what you think? Probably not. We both agree. Okay.
You have to remedy a situation, and unfortunately it wasn't my case. Here before, the master on the record ordered a result of an interlocutory order brought by an inspector to vary an order of a high court judge to provide for the directors of the corporation to be responsible for the inspector's cost. The situation was there was an inspector originally appointed as party and then confirmed by all parties where the order provided for the corporation to pay the accounts. Turns out the corporation had no assets. The inspector wanted to be paid by the directors of the corporation. The motion comes on a week before. The judge doesn't make a decision, but refers the whole thing to the master. That's outside the jurisdiction of the master to determine. It wasn't an assessment, it was the actual liability issue. The solicitor involved thought he could appeal. The second high court judge involved probably incorrect. It doesn't go beyond the interest of the party. Wouldn't appeal. Solicitor thought, well, maybe I can vary, try a second time to vary, and perhaps the order is incorrect. So the third high court judge, like the fact it's coming up again, you're not before the master of the reference, the master doesn't have jurisdiction.
Well, I think the master does have jurisdiction under the reference order, you see. That if the whole...
is outside the four corners of the rule, which says the master can deal with certain issues. It's clearly not within those four corners.
Well, I think, either the master does have jurisdiction because of the reference order and its breadth, and keeping in mind that the judges have said that they don't have or they're not going to, so he has. So you take a practical approach and do it, or at least hear the case on the merits. Or I suppose if the master says he doesn't have jurisdiction, then another high court judge is going to perhaps take more notice. When I say I don't have jurisdiction, then perhaps when you go to court and say, I don't think the master has jurisdiction without ever having argued it.
Can you, is it open to you at the beginning of the reference to argue that's not the same as order?
It's open for you to argue anything. The result, I don't know. I don't know how. I don't know. But I would say that the language of the reference order is very, very important.
Alan, I'd like to ask a question of you about security for costs and shell corporations. You've talked about the shareholders' responsibility for the costs that may be ordered against the corporation, but not all commercial relationships are that simple. The shareholders could be limited partners. One of them could be a company that's impecunious, and creditors of them could have an interest in the proceeds of the litigation. How far back up the trail of the ultimate beneficiary of the litigation do you see the court going in making security for cost orders where shell corporations are concerned?
It's helpful to keep in mind the fact that the corporation without assets is put in the same sub-rule and is juxtaposed with all nominal plaintiffs. And I think it's possible to convince the court that they should take a liberal view of it and really track down who is ultimately going to be the beneficiary, because the rationale for the rule has been expressly stated by the court to be the ones who are going to be the beneficiaries must bear the corresponding obligation for costs. And while I guess practically there may be limits on how far down that road the court is going to allow you to go at that stage of the proceeding, I think you should be creative, because I think the courts are willing to be
persuaded. And the other question is, what is impecuniosity? It's a rather vague term, and it hasn't been defined very much to date, because most of the cases are ones in which the shareholder of the plaintiff puts in simply no evidence. But I think you can do a lot of digging, and ultimately, although the court may not say it's a limited partner or somebody else who's going to be responsible, the court may simply say he's not satisfied of the impecuniosity of the shareholder, which is going to have the practical effect of making that third or fourth or fifth party removed be the one who's going to pay the freight.
Master Sandler, I have a question of you with respect to counterclaims alleging an abusive process. What happens to the solicitor-client privilege that might otherwise be there for a plaintiff bringing a claim that is said to be an abusive process or champertus? Can, on examination for discovery, one ask for contents of the solicitor's file insofar as they relate directly to who's giving instructions, who's funding it, who's going to get the benefit of it, whether there's an agreement to split up the proceeds, and whether there's a collateral purpose to the whole action, whether it's really designed to force somebody to do something in another agreement?
Two things. There are some cases holding that solicitor-client privilege is not absolute, and that where it must yield to other valid and overriding public policy concerns, it will be so overriding. And it seems to me that that principle might be applied in that situation to allow an exploration of the plaintiff's discussions with his lawyer and that sort of thing. That's one argument. There's another principle that says that where the very issue that's raised in the lawsuit is directly related to the solicitor-client privilege, that it's either a question of waiver of the privilege, or again, the court will override it. There's a case of Mr. Justice Grange called Novak, where it was in a different context. It was a plea of non est factum. But she was asked all kinds of questions about what her lawyer said and what advice she was given because she raised it. So it seemed to me that on either of those principles, you could then, and I assume the questions are relevant, I'd have to look carefully at the way the cause of action is defined, but assuming the questions are relevant and it's only solicitor-client privilege, I think it may well be invaded in that situation, mainly based on the fact that solicitor-client privilege is not absolute, as much as solicitors would like to think it is, but it can be overridden.
If I could just make an additional observation, something that occurred to me this morning on the security for costs motions is I asked myself, could you ask the plaintiff on an examination who was paying, whether the lawyer for the plaintiff was being paid and who was paying the lawyer? I don't know whether the source of the fees is subject of privilege in the first instance. In the event, there may be an argument that the privilege shouldn't apply. And I say that because there's one case in which I think Mr. Justice Galligan held that the plaintiff hadn't established its impecuniosity simply because the litigation had been fueled for 3.5 years, and he thought that was an appropriate consideration. So it's a question that I think somebody ultimately is going to have to decide.
Of course, the question isn't who's paying for the litigation, but what assets the plaintiff will have at the end of the trial and now to pay costs. I'm not sure that who's funding the litigation. Well, it might be because the argument is that the corporation isn't funding the corporation isn't funding the litigation because it's impecunious. But usually the issue that as I experienced it, isn't whether it's impecunious or not, but rather the plaintiff comes in and says, I am impecunious. There's just no question about it. But let me proceed anyhow. And that's really the way in which the issue most frequently arises. It's not usually a contest with the plaintiff saying, I have money, and the defendant saying, I don't. Usually the plaintiff tries to admit it or concedes it or what have you, and says, notwithstanding that. Now, what the cases have held is that a plaintiff can't admit his own impecuniosity. He has to prove his own impecuniosity. And it may come up in that context. But usually the situation is the plaintiff is impecunious. Can he still proceed in notwithstanding that? There is a case in my papers on the question of cross-examination on affidavits in relation to security for costs, where the judge talks about if you let it go unchanneled, you can ask any question about anything in a security for cost motion, much like an injunction, because it's such a broadly scoped motion. And the court said, however, there are limits that ought to be imposed when any examination or cross-examination goes beyond limits. And I think she said, McKinley said, I'm sure the courts are up to the task of limiting the cross-examination. So, it's just not borderless. There are borders. The question is, where are they going to be applied in any particular case? But you might be able to get into that. I have a question to ask you, Paul, if I might, on limitation periods. Plaintiff seeks to add a new cause of action, or more dramatically, seeks new parties to an existing action and is successful on the motion, being allowed to amend, to add, notwithstanding that a limitation period is passed. Does that preclude the defendant at the trial from raising the issue of limitation periods and arguing that notwithstanding the fact that the plaintiff is allowed to become a party to the action after the limitation period has gone by, that doesn't foreclose the defendant from relying on the statutory provision in the particular statute of limitation, which says this cannot be done?
Well, I think that's a great question. That happened in a case in British Columbia where a plaintiff sued 5 defendants. One of them had a limitation defense because of the circumstances. It argued that it shouldn't be joined. The argument was rejected. It appealed to the Court of Appeal. The argument was rejected. It was found and said in the Court of Appeal's reported case that this party was a proper defendant. The case then went to trial. Meantime, defendant pleaded the action was out of time. At trial, the trial judge said the action's not out of time. The Court of Appeal has said it's in time. The defendant, at the end of the trial, appealed to the Court of Appeal. Same Court of Appeal that heard the appeal on the pleadings. The Court of Appeal said, well, just a minute, that order was interlocutory initially. This is now at the trial. We're going to find the action is out of time against the defendant, and it just so happens there's several, not joint liability in British Columbia, so the 20% recovery that would have been enjoyed against that defendant is gone. So that's what happened in that case in British Columbia. To me, there's no one answer that applies. I think the general answer is that when the order is made allowing a party to be added, the joinder it's an interlocutory order. The party can still plead a limitations defense and deal with it at trial. That's the way that I think myself it is generally. However, in some of the statutory orders that are made extending time, they are final. And then in some of the cases that are made extending time, the judgment gives leave to the defendant to allege the limitation period. Those latter two cases are different. The statutory extension of time is final. The procedural, the permission to add a party but defer the limitation to trial, well, that's easy. It's very, very clear then that its limitation can be pleaded and dealt with at trial. And sometimes, as happened to me recently, you get a mixture of them all in one case.
Can I just add, there's a reported Ontario case that deals with it. I think it's a decision of Mr. Farron's when he was dealing with non-bankruptcy matters. And if memory serves correctly, he held that the relevant date is the date of the writ. And so if you're added later, the addition relates back to the date that the action was commenced, even though the party was added 3 years later. He dealt with the problem by imposing as a term of adding the party either that it was without prejudice to any limitations defense, and B, that for purposes of any such issue, the writ would be treated as having been issued against that defendant on the date that he made the order. And I think if he hadn't imposed those terms, the law that he had cited would have put that defendant in the position as if the writ had been issued 3 years before when it was issued against the first defendant. But I don't remember the name of the case, but it's reported.
I don't know the answer to that, and the answer is in class actions, not limitations law, to me. It would depend, wouldn't it, on whether all the members of the class stand in the same position on the limitations issue? And that varies from one class action to the next.
Same thing would apply in a release situation. Supposing the person who was asserting the class action had signed a release in favor of the defendant, so that his particular individual claim was barred by the release. Would that now affect the entire class? I would tend to think not.
Well, I think there's a reported case that says if the named plaintiff himself is barred from bringing the claim because of a release or limitation period, then the action itself fails. The really interesting question is what happens if you have, say, a release and the action is started in time. 6 months down the road, the action is dismissed because the particular plaintiff is without status for whatever reason. Then the limitation period vis-a-vis the rest of the class expires before some other member of the class can commence the action, and that's when you get.
Or could you bring a motion to amend the style of cause to substitute for the person?
No, there's authority that you can't do that.
I don't know it yet. I mean, no question.
Well, what I'm thinking of when I say that is that if there's a motor vehicle accident in Quebec and a Quebecer sues an Ontario resident in Quebec, then for two reasons, the Quebec court is not going to apply the Ontario Highway Traffic Act limitation period. But if the Quebecer came to Ontario, which just happens to be where the defendant lives or has moved since the accident or where his insurance company's head office is or something, Ontario law is applied. Ontario's highway traffic law is applied. And there's a 2-year limitation period. The action may not be statute barred in Quebec. Maybe it's a bad province to give as an example because of their no-fault laws, but they didn't have them always. And the case in my paper deals with this, and the Quebecer comes to Ontario, and Ontario's highway traffic law applies, which doesn't seem to make much sense because that statute deals with the rules of the road of Ontario. The accident didn't happen on Ontario roads. But because of the procedural nature of limitations, the Ontario court disregards the Quebec limitation and adopts its own, which may have no real purposive application, but that's the way the law is. Does that answer your question? Well, I see what you mean. Our limitations law applies. I don't know of a case that decides whether it's reasonable or not for that out-of-province person to fail to know about our law. I think that would be something I have to think about. But Ontario's law would apply. If they're coming from Nigeria, the Nigerian law would not apply. Ontario's law would apply, and the case that's given to you in the paper does say that even though it may be quite unreasonable to apply the Ontario law or harsh, it applies to the foreigner coming to Ontario.
There's a question over there.
Mr. Sandler, I have a question on sealing documents. You mentioned the British Columbia case of Black Minerals and Newsinch.
No, I mentioned the Ontario case of Black Minerals and Newsinch. I agree that there's a British Columbia case going the other way. Yeah.
Well, my point is this. As I understand the reasoning about not using discovery information for ulterior purposes, that's an implied undertaking given by counsel and part of the procedure.
In Ontario, that's what one judge said. Yes.
When you file transcripts for use on motions or for any other purpose, the party is now put it out of its control to comply with that undertaking not to disclose. What protection is there against the person who's given the information about letting that information out into public domain?
Well, you're making an assumption that you file the transcripts on a motion, and once you have, they're there. I don't think that's the situation at all. I think that what happens is you walk in with the transcript in your back pocket, you lend it to me, I read it, and then I give it back to you, so that you haven't filed it as such. But you do have to file it with the record for trial, because the trial judge has to, I mean, at some stage, the transcripts have to be placed with the trial record, because the judge has to have his copy when you start reading in your discovery as part of your case. Just at what instant that occurs, I'm not sure in terms of setting a case down, and I know an awful lot of trial records don't have the transcripts. I just don't know. Maybe Ted can help us on that. But I just make the point that when you argue a motion before a master with respect to disputed questions on discovery, I don't think what's happening is that you are filing the transcripts and that thereafter you can't get them back again. In fact, I follow the practice when I'm given a transcript of giving it back to the counsel, if that helps you. But I think Ted has a response, and then there's another question over there.
At trial, my experience has been that you file the discovery transcripts 3 minutes before you start the case so that the registrar's got them when they're needed, but we've never filed them before, and I've never been yet in a case where anybody has filed them in advance.
See, when I was practicing, it was different because you had to file them. But now, do you keep the transcripts in your office, the court's set, at the opening of trial, you give the judge his copy?
You keep court copies, and when you show up at trial, you hand the registrar, here's 6 court copies of the 6 days of discoveries. When we come to it, you'll give them to his lordship.
But answering your question, supposing, for example, you prepare a motion record, and you put in 30 pages of the transcript in the motion record as the part that contains the questions. And that's the way you frame your motion record. And that's very common. I applaud that kind of thing. I don't think that's breaching your implied undertaking not to use it for any purpose, because you are using it for a legitimate purpose, and that is the conduct of the action. And therefore, even if Black Minerals Ontario is right, even if there is an implied undertaking, I don't think you're breaching it by doing that.
May I ask a supplementary?
One supplementary, then the question.
Who, if anybody, would be to blame if the contents of that discovery appeared on the front page of the newspaper the next day, and the person who had been examined for discovery felt that his privacy had been invaded in a way that constituted breach of the implied undertaking?
Who would be responsible?
Would there be anybody to blame for that?
Nope. The newspaper, but I mean, then you got a charter argument about freedom of speech and what have you. I think that if you really want to get at the transcripts for discovery, if you're some kind of person who wants to splash it around, it's pretty easy to do.
Yeah, sure. I don't like misnomers, particularly when it's a deliberate failure to give the correct name. If you don't know the correct name, then that's the real situation. To invent a name and then later say that, well, I mistitled a person's name, it isn't a valid misnomer. So that, yes, but that's not a I appreciate the problem, but it's not a misnomer. A misnomer is the incorrect spelling or title of a name or corporation or business entity. So I suppose out of caution, you might try to put it in as a misnomer so that you can try to get the benefit of the law of misnomers, but you really shouldn't and can't later. The way you posed your question was, are you better off doing that than doing nothing? And, you know, putting it that way, maybe so, but I wouldn't be high and hopeful on getting an amendment on the ground that it was a misnomer. It probably would be better to go in on the real ground later. Yes, or to serve a notice of action and bring a motion for disclosure of the names of the persons that you need. To do that, there must be something that can be done up front that isn't an invalid misnomer.
I take it that your question is whether you should try the John Doe route before discovery, before the limitation expires, or wait until discovery when the limitation is going to have gone by because it's close to expiry, and get the names. Given that choice, the Richard Roe, John Doe type of game has been commented upon, and the current leading case draws a distinction, it's a high court judgment, which draws a distinction between not knowing who the person is and not knowing their name, and knowing who the person is who harmed you, but not knowing his name, his or her name. And it was in the context of nurses in a hospital. If you know that there was a nurse, she was a real person, she worked on you, she pulled the needle out, she was the one who was negligent, everybody knows it, there was some kind of proceeding, she's a real person, and she did something that might constitute a tort, but you don't happen to know her name and can't get it. That's a situation where Richard Roe, John Doe procedure can be used validly. But on the other hand, if you think that there were some nurses who might have been involved in your mishap, you don't know, there were doctors, nurses, orderlies, so you add John Doe or Mary Roe to represent potential nurses who might come along, then that's where it's improper to be used. So, given your fact situation, if it's before discovery, and you do have a specific person who you know harmed you, you just don't know their name, I would definitely go the John Doe, Mary Roe route, because it's authorized and it avoids the whole limitation period argument. Because I think it's a real problem about, you see, there's a lot has been made about judges allowing parties to be added after limitation periods, but they haven't addressed the big issue. Take yourself forward 2 years to the trial, and the defendant now stands up and says, I've pleaded limitation period and I want to argue limitation period. And you, trial judge, do not have the power as a trial judge to override the statutory provision in the Limitations Act, the Health Disciplines Act, or whatever, that says you can't do this. And I know there are lots of cases on it in England. There are several more in Ontario. There have been a number of academic papers written on this very issue, and I think it's far from certain. So that I think too much has been made about limitation periods dying or being ignored in the context merely of adding parties after the limitation period has gone by. And you can only make that argument that limitations are of no effect when you get rulings by trial judge and appeals, like the Court of Appeal in that infant case. That was after a trial, and they applied the law, and that's where you're going to get significance. And in that context, I don't see limitation periods falling.
I think that we should have as our next question, what's for lunch, because the schedule is
Right.
from 12 to 1:15. Can we come back at 1:15, please?
Much of your time. I'd like to introduce the panel that will be dealing with production and discovery matters. Starting to my far right, we have Janet Gross. To my immediate right is Patrick Schindler. Moving over to my far left is Marianne Sanderson, and to my immediate left is Joyce Harris. We will also be joined this afternoon by John Campion, who isn't here yet. John Campion, you don't have his CV, so I'll just tell you a little bit about him. He's a partner in the firm of Fasken and Calvin, and besides his extensive practice in civil litigation, he's a lecturer in advanced civil procedure at Osgoode Hall Law School. and as well a lecturer on a wide-ranging series of topics before the Law Society of Upper Canada, the Canadian Bar Association, and the Institute for Public Analysis. Immediately following the conclusion of the individual presentations, there will again be a panel discussion and a time to ask questions, and that will be moderated by Sheila Block, who is sitting in the middle on my left side. Sheila is a partner with the firm of Torrey, Deslauriers and Binnington. She was called to the bar in 1974, and since that time she has practiced civil litigation. Would you please welcome our speakers this afternoon?
Can you imagine that when I was asked by one of the organizing committee to speak on problem examinations, misconduct of counsel, that I felt a little defensive? And I asked the committee member, was I thought to have special knowledge on the subject? And if so, was it as a misconductor or as a receiver? She's escaped to the audience, but she gave a non-committal laugh. And so here I am, into the fray. My paper is at I, by the way, but it may bear little resemblance to these remarks. You can look on it as a challenge or two for the price of one. Problem examinations. How to avoid them? As in other areas of human endeavor, I think we have found that the only safe method is total abstinence. I once had a partner who came back to the office after having an examination for discovery with a problem counsel. He was white, sweating, shaking, totally unnerved, and he said, "Life is too short. I am never taking a case against that expletive deleted fellow again. I will refer them out of the office if need be." And he did. That is total abstinence. I once had a client who attended with me on an examination for discovery, where he was examined and roughed up considerably by a problem counsel. After the examination, he was white and shaking and sweating. And he said, "Where's the nearest bar?" And we went to the barrister's lounge in the Hotel Toronto, and he told me over drinks, "Get me out of this lawsuit. I don't care what it takes. I don't want to see that fellow again. I'm not going to trial against him. Settle the case." I said, "But that's what he's trying to do." He said, "I don't care. He's won." That is total abstinence. I do not believe that we will grow up to be good counsel if we abstain in that fashion. I think we have to come to grips with the fact that, as the Alan Lenzner interview at page 1 of my paper shows, what we do as counsel, Lenzner says, is to get up in the morning and go to work and fight. We may not have cauliflower ears or broken noses or missing teeth like some kinds of fighters, but we have our scars, I guess, on our souls or our psyches. And if you don't like to fight, you might as well hang up your gown. Speaking for me, if there's a choice between the total abstinence and those problem counsel, I would sooner be the sort of counsel that other people will abstain from fighting against, rather than giving up myself. So come to grips with the fact that, to mix metaphors a little bit, if you're going to go into that particular kitchen that we've chosen to make our living in, you're going to feel a little heat. You may even get burned, and you may burn. And the thing to do is to keep the conflagration to manageable proportions so that you and your client, neither you nor your client, will go up in flames. How can that be done? As I observe at, I think, page 2 or 3 of my paper, these problem examinations don't usually come out of the blue. They usually follow some bad blood or some preliminary fighting that's gone on either in the last movie or in interlocutory proceedings in this particular proceeding in which the discovery is being held. One way to try to keep the fighting to a civilized proportion is to sacrifice some of those preliminary skirmishes or complete success in them. Your mother may have told you, be nice, be polite. Your father, who at that stage of history had been out in the world a little bit more, may have told you, yeah, but nice guys finish last. And like a lot of parental advice, they're both right and they're both wrong. On the one hand, I have found that some of my most civilized and professional and enjoyable discoveries have come when I have resisted the temptation to attack my friend's pleading, where I have been content to accept his witness that he chooses to produce, and where we haven't had any fights about who's going to conduct the examination first, where I have foregone the advantage of going first and finishing my examination, and I act like a nice guy or a lady and have my secretary call up and arrange the examinations of all parties at mutually convenient times together. But on the other hand, nice guys sometimes do finish last, because it's happened to me, no doubt to you, that if I say to my secretary, call up Mr. So-and-so and find out what is a good time for him for us to have discoveries of both sides, my secretary will eventually get an answer back from the secretary on the other side saying, Mr. Jones or whoever doesn't have a free day for the next 6 months. And then you're sorry that you were nice. You could have served an appointment on reasonably short notice and got on with things. If you're plaintiff, that's something to worry about. It's also happened to me that while I have been trying to be a nice guy and arrange mutually convenient discoveries, the other side takes advantage of my niceness, serves me with an appointment so that he can conduct his examinations and finish them all, because that's the rule, before I get to start the examination. So sometimes niceness can be a handicap. But let's say you get into the examination, whether you've had these preliminary skirmishes or you haven't, you're in the examination and you sense that things aren't going as you would wish them to go. Let us suppose that you are questioning and you're getting a lot of argumentative objections. You can try to hold your friend on the other side to the requirements of the rules, to restrict him or her, I guess I should always be saying, to the requirement of the rules simply that the objection be made and the reason stated and get on with it. You can do that by saying, let's fight about it somewhere else. What's your objection? And then move on. You can try, if it's really tense, stopping for a coffee break, and the good jelly beans that they seem to have around at all the official examiners now. You can try cracking a few jokes to break the tension. You can try smiling sweetly at the other side and being polite, not losing your temper. That has boomeranged to me too, the smiling sweetly, by the way. Perhaps the sight of me smiling sweetly is so startling, I don't know, but it did drive an opposite counsel into a frenzy once. Sheila asked me if I was going to tell this story, and I wasn't, but I will. I was trying to be on my best behavior, and this apparently was very provocative to the other lawyer. He is the lawyer who is cited in my paper at an early stage in the Dumbo episode and the spilling coffee episode that you may have read about in the Ontario Lawyers Weekly. On this particular occasion, what happened to me was that he snatched my correspondence, Brad, started ripping up the carbon copies of letters and spilling them all over me like confetti at a wedding. Yes, it happened, and I am here to tell the tale, and I'm laughing about it. I was not laughing that day. As I say in my paper, don't do as I do as I say. Keep your cool. Don't lose your temper. What I in fact did on that occasion, I am ashamed to admit it in public, but I must, so you'll have heart that you can live through the experience. I retired to the ladies' washroom and burst out crying. Do not do that, especially if you are a male counsel. What I would do today in that situation, being a little more battle-scarred and more experienced and having the advantage of Rule 34:14, is to use that rule to adjourn the examination, cut short the agony. You don't really have to have that kind of treatment inflicted upon you. You don't have to have either, by the way, on the record, as has also happened to me, senior counsel saying in front of my client, multiple lawyers and the reporter, Mrs. Harris, every time I have an examination with you, I am reminded of why I was opposed to women being called to the bar. You don't have to have that happen. You can go to Master Sandler, have a very nice transcript, nice from your point of view, and get a ruling on the propriety of things. Now, under Rule 34.14, it's quoted in my paper at page 4 and 5. If the examination is being conducted improperly, under the circumstances which are quoted in the rule, you can get a ruling as to what should happen next. I tell you in my paper that I'm only aware of 3 cases under that rule, and Master Sandler was kind enough to make available to me his mammoth files of reported and unreported cases. By the way, if you are a misconducting counsel, you will be filed in at least 4 different filing drawers of Sandler's cabinet. So watch it. You are down for all times in many bad books there in that office. At any rate, there are 3 cases. They're cited in my paper, and I'll just mention them very briefly. The Eversonic and McGurr case is a case that I'm sure has happened to all of you, what I call the speechifying witness. One of the situations in which you can use 34.14 is when the answers given are unduly lengthy. Now, Mr. McGurr is a senior official of Price Waterhouse. He was a very experienced witness. He'd been in court, no doubt, more times than the counsel examining him on that examination. He was too clever and skilled at the game to give any kind of sort of clear, concise admission that you could stand up at trial and read against him. So what he did was, and it was all held to be legit, by the way, by 2 courts, the master and the judge, he buried the answer within the speech. Counsel examining him didn't like it and went to the master and lost, went to appeal and lost. Mr. Justice Southey agreed with the master, who said, it can't be unduly lengthy if it's responsive. And both counsel agreed that there was a response there, that kernel in the middle of the argument in the speech. So the counsel objecting found that Rule 34.14 did not help him there, but not many witnesses will be as skilled at using the answer to further his case as the particular party in that action. The other 2 cases are the Kingsburg case before Master Pepiot and the Canadian newspapers case before Master Sandler. The Kingsburg case illustrates the danger of losing your temper too fast. You have all, I think, had it happen to you where you want to walk out, or the other side says, we're going to walk out, and makes a gesture as if to pack up the bags and go. If you go too fast, then you may be booted out of the master's office. Now, Kingsburg was not exactly like that. It was a case where the questioning counsel kept asking questions. The party's counsel kept objecting on the grounds of relevance. And as Master Pepiot put it, at a very early stage, it was clear that they were, quote, at loggerheads about the scope of the examination. Being nice guys, they were both gentlemen, professional, civilized, mature counsel. Master Pepiot said so. They decided, why waste the time? I mean, I'll keep asking, you'll keep objecting, this can go on. I mean, and we're paying $2.50 a page or whatever we're paying. We'll just use 34.14. But Master Pepiot held that that was an improper use of 34.14. The word improper in the rule, and you'll see it's repeated and repeated in the rule, means, he said, something more than a legitimate disagreement between counsel as to the propriety of the questions. There has to be some element of misconduct. And also, he felt it was very difficult to rule on propriety of questions in a vacuum. So he sent them away to go through the question-answer that no doubt resulted. In the case before Master Sandler, there was misconduct of counsel. In that case, After 66 questions, the questioning counsel adjourned it. Some people might have thought that that was a little too hasty, but he was very clever. He set up the record so well, and the parties' counsel played so foolishly into his hands that he had a perfect vehicle to go to the master's office with. What happened there was the parties' counsel passed notes, one of which said, "Speak louder." The parties' counsel reminded her client of how the question should be answered, suggested answers, and interjected on a number of occasions, both out loud, where the questioning counsel could hear, and more quietly, where he could not. Master Sandler held that these kinds of private communications between counsel and witness as to the scope of the examination or the manner in which questions should be answered was highly improper. He analogized to the situation where you're in the trial and you're cross-examining a witness. The other counsel could not pass notes up saying "speak louder," or could not, coach the witness from the counsel box or counsel table without getting some severe reprimands from the trial judge. And he held that analogy enabled him to say that kind of help between counsel and witness offends the rules. That counsel, I said she helped her friend to create a perfect record. She displayed her inexperience, perhaps, in that she couldn't see a difference between her helping her witness and the co-counsel on the other side of the table, junior and senior partners, helping each other as to what questions should be asked next. Master Sandler made the ruling sought by the questioning party, but he declined to award costs against that offending counsel. The moral of that story is, if you think you are a misbehaving, misconducting counsel, try to seem stupid rather than bad-intentioned. You will be laughed at in the ORs when it's reported, and this one was, but at least you won't have to bear the cost, because the element of intention was what played on Sandler's hard heart and kept him from ordering those costs which were sought. Now, there's one other bit of advice I can give to you, how to avoid problem examinations. That is, listen very hard to Patrick Schindler's talk on written interrogatories. They may be the answer. Da-da-da.
Well, they may be the answer, certainly for somebody who doesn't like to have coffee spilled over his or her discovery notes. And the more I hear about problems other people have encountered in examinations for discovery, both when they're examining and when a representative of their client's being examined, the more I think that there must be a better way. And in 1985, when the new rules became effective, written discoveries were introduced. In some circumstances, I think they are a better way. Written discoveries came into effect with the new rules of civil procedure at the beginning of 1985, and in comparison with oral discoveries, I think there are both advantages and disadvantages, hence the title of my paper. The relative advantages can only be assessed by looking at what discovery is all about, so I've reproduced for you the divisional court decision in Malafy and Andrew Merrilees. The purposes are to enable the examining party to know the case he has to meet. That's to find out what information you can't find out yourself, that you can only find out by asking the other side. To procure admissions, that's to help you prove your case. To procure admissions which may destroy an opponent's case, to facilitate settlement, pre-trial procedure in trials, and to avoid surprise at a trial. I think the primary purpose is, of course, the first two, to find out things that you couldn't find out otherwise, and also to assist you in proving your case. Each of them may be a crucial consideration in deciding what sort of discovery to hold. For counsel conducting litigation, you've got to analyze these relative advantages and disadvantages in the context of all the available discovery procedures, and there are many. I don't think we need to go over them in detail, but just keep in mind that the various devices available under the rules include discovery of documents under Rule 30. You can get discovery of documents from third parties. There's going to be more about that later today. requests to admit facts and documents. Now, this may not seem on the face of it to be a form of discovery, but it is really, when you view discovery as having one of its purposes, obtaining proof. Sometimes, to be quite frank about it, you know you can't succeed at a trial unless certain facts can be proved out of the mouth of the other side. And if they'll admit them, or on discovery or in response to a request to admit, you may get yourself over what would otherwise be an insurmountable hurdle. I know because I've done it. I've sat there and looked at the answers or the response to a request to admit and realized now I can go ahead. But without it, I couldn't, because there are certain facts there that I couldn't have proved because there was no witness available that I could use. So I view that as a form of discovery in the sense of being able to obtain proof. Oral examinations, including examinations of non-party witnesses, of course that's discovery. Experts' reports are a form of discovery, finding out what you need to know before trial. There's specialized disclosure in matrimonial proceedings. There's inspection of property, there are medical examinations, and there's also pre-trial examination of witnesses under Rule 36. All these I view as part of the equipment for finding out information that you can't find out yourself and also obtaining proof, particularly of things that you couldn't prove yourself. Written discoveries are provided for in Rule 35, and although written discoveries are new in Ontario, they're not altogether new. Rules of the Federal Court of Canada have permitted written discoveries since 1970. Provinces of British Columbia, Manitoba, and the Maritime provinces all provide for written interrogatories. The rules of the federal courts in the United States and in many of the states of the United States permit written interrogatories. And finally, written interrogatories have been permissible in England for a long time. In fact, in England, and I gather in other Commonwealth countries, including Australia, for example, those are the only standard forms of discovery. You can get oral discovery in England, but only if you've applied for and obtained an order to conduct written discoveries, and the answers are so unsatisfactory that the court will order the witness to attend and submit to oral examination. But that's a rarity in those countries. So those countries have a large experience of written interrogatories for us to fall back on if we need jurisprudence to rely on. Before I go further, let me say there's one difference between my paper and many of the others in the material in front of you. I have very, very few decided cases to refer you to and let you take away to mull over. There simply have been very few on written interrogatories in Ontario. But when you go to use them, obviously you're going to have to look at jurisdictions where they've been available and import as far as you can the jurisprudence from those countries in your arguments. I think the unavailability of written interrogatories in Ontario until now is anomalous. I think now that they're available, what's even more striking is that people aren't resorting to them as much as they should. Mr. Justice Solmon in the Duke of Sutherland case said about 60 years ago, he said, "I doubt myself whether interrogatories are administered as often as it's desirable, and although I should desire to keep interrogatories strictly within the legitimate limits within which they're permissible, the administering of interrogatories seems to me to be, speaking generally, a step which is more often desirable than undesirable." Now that's a rather low-key sales pitch for them, and it's in a jurisdiction in which they're the only available form of discovery. But I think those comments are equally appropriate now that we have them here. I think they should be resorted to as often as an analysis of the advantages suggests that they're going to be preferable to oral examinations. The preference in this jurisdiction for oral examinations and the wariness about written discoveries seems to me to rest on the fact that people feel generally that written advocacy isn't going to be as effective as oral advocacy, and that written questions and answers aren't going to get at facts as effectively as oral. I just don't think that's the case at all. I think in many contexts, written material is more persuasive than oral, and I think in many contexts, written questions get at detailed, specific, complex information more quickly and effectively than oral. I think they're also effective in quite the opposite kind of case, where it's very simple and straightforward, and where for reasons of costs and inconvenience, you just don't want to have to bring witnesses all the way to a special examiner's room to ask him or her half a dozen questions which could have been dealt with very simply in writing under oath. Now, let's begin why you'd want to have oral examinations. Beginning at the top of page 5 of my paper, I say that where you've got witness statements that tell you what the story is about, where you think you can prove your whole case, where you think the principal defense witness is not credible, and you've dealt with him so you know that, and where you think that your cross-examining skills are up to demonstrating that at a trial, well, then why bother with going through the very expensive, time-consuming, delaying rigmarole of an oral examination? And when I say delaying rigmarole, I mean it quite seriously. Joyce Harris has pointed out that when they're busy counsel on the defense side, and my experience has been all defendants' lawyers are terribly busy, then you may have to wait months to get a mutually convenient date. And then you may find that the witness is also terribly busy, and defense witnesses often are, with the result that the time period from the close of pleadings until you've completed examinations for discovery can stretch out easily to 2 years. I think all of us have seen that. And if that is a rarity, well, certainly examinations that spill out over a year or more are all too frequent. Written examinations seem to avoid that. The other thing to keep in mind, if the witness, the principal witness, the other side, who's the witness you're going to get on a discovery, is not a very candid sort of person, what I refer to in my paper as a palpable liar, what sort of admissions are you going to get? Why bother going through it all if all you're going to get is obfuscation at every turn? Those are reasons that ought to caution you against the feeling that you've got to have oral examinations before you go on. Now, getting a feel for the other side's principal witness and laying a foundation for an effective cross-examination, particularly in credibility cases, is the most important advantage that's put forward in support of having oral examinations for discovery. But there's some serious reservations to this advantage, in my view. First, it presupposes that there really is only one principal on the other side, and particularly in commercial litigation, although it's true of a lot of litigation, there are numerous witnesses may be called. You're not necessarily going to deal with the credibility problem of the main principal witness, the other side. There is some litigation, of course, which that's not the case. There will be only one available witness for the key facts, the other side, and then perhaps oral examination is more useful. But it also assumes this whole idea of getting a feel for the other side's witness and laying a foundation for cross-examination, that you're going to get more from examining the witness than the witness is going to get from being examined. And I don't think there's any education in how to be an effective witness quite like sitting through days and days of rigorous cross-examination by a competent counsel. I think it coaches the witness. And if you're going to be counsel at trial, it coaches the witness to all your strengths and weaknesses too. I think you can often prepare the witness more than you prepare yourself that way. Now, getting a feel for the witness is one of the three advantages usually put forward in support of having oral examinations. And the second one is that in oral discovery, follow-up questions can be posed immediately. Now, that's said to be an advantage. And I suppose in some cases it is an advantage if you follow the hot pursuit theory, if you're just going to be following up what a witness says as he or she says it, until eventually you can trap them into admissions that they didn't want to make or back them into a corner unexpectedly. Maybe sometimes hot pursuit is an excellent advantage of oral examination. But sometimes it's a disadvantage, and I'll have to explain why I say that. Oral examination is a peculiar hybrid sort of thing. The form of the examination follows the conventions of oral communications between people, oral conversation. Sometimes when you hear what Joyce Harris said, it follows more the conventions of recess in the schoolyard, but actually it's supposed to follow civilized conventions of oral conversation. But
Are you speaking of what I said or what I spoke about?
The subject matter. But the product of an examination for discovery is written, and it's used in its written form. On procedural motions and at trial, you're dealing with something in writing. Now, it's such a trite point. Perhaps many of us have got over it and have forgotten it, but we all had to learn it in the first place, how to carry on a conversation according to conversational conventions, and at the same time come up with a written product that actually works as writing. And you know, there are all sorts of circumlocutions we use in the language to try and deal with the fact that now I'm showing you, and all these extra words we throw in there are to turn something that's an oral communication into writing. And one of the things we've got to remember about oral conversation is that it proceeds in short segments. You ask a question, you get a response. You follow that up and you get another response, and so on and so forth. It proceeds in short, choppy segments. That's how conversation works. It works that way for two reasons. You've got to get both people talking, but also because there are limitations on the memory for the spoken word. So that when you start asking somebody something, he gives you an answer and you follow it up. It doesn't go on for very long because neither of you can keep in your heads what's said orally more than a relatively finite amount of information. This restriction does not apply in the written form. Now, I've included excerpts here of two sets of oral examinations for discovery, and then followed them in each case with a suggested form of written discovery that would do it. I have borrowed from somebody else's discovery of my client, not out of any sense of nastiness, but because I don't think, under the rules I understand about implied undertakings not to disclose information in discoveries, that I should be putting in public information like this what I've asked other people. So I've done it the other way around. This was an examination of my client. But what I'm trying to illustrate by picking these two excerpts here, and I'm not going to read them now, if they're of interest to you, read them later, and they may suggest you devices for how to frame written discovery questions. But my point in both of them is that much more information is obtained much more efficiently from the written form of question and answer than from the oral. And particularly in the longer section, which begins at the top of page L9, you have the very frequent problem that you get into in technical issues and examinations for discovery, the fact that the lawyer asking the questions, a very capable counsel, quickly got at cross purposes with the witness, and neither the witness nor the lawyer really completely understood what the other was saying, and it goes on with things sort of slightly and subtly missing the point until neither of them is really getting what they want. The witness isn't saying what he really meant to say because he's having questions that are difficult to answer, and the lawyer's not getting the information he wanted. It can all be done so much more simply by asking relatively simple, straightforward, written discovery questions. And I leave it to you to read the oral and the written versions to see if you don't agree that the written are more informative than the oral. But more importantly, there's no loss of follow-up in the written, because in the oral version, the lawyer actually lost track of one of the items that he wanted to follow up. So he actually, through the confusion of it, forgot to pursue one of the lines of inquiry. You don't get that in the written. Now, immediate follow-up that you get in oral discoveries, I think, can sometimes be a terrible disadvantage, because you have to follow it up immediately. Sometimes you become aware for the first time when you read the transcript that the witness had qualified his answer in a way that you didn't appreciate at the time, because you didn't really understand what he was saying. And I think this is one of the most difficult things about oral discoveries, is keeping your ears open to what's going on at the same time as following your line of questioning. And if you stick your nose down and you go through the list of questions you intended to ask and pursue them without listening carefully enough, you can miss things. And I think that's the biggest difficulty we face in oral discoveries. In written discovery, you have the luxury of reviewing the written answers before you pose your next set of questions. Rule 3504, paragraph 1, provides that where an answer suggests a new line of questioning, the examining party may, within 10 days after receiving the answer, serve a further list of written questions which shall be answered within 15 days after service. If the 10-day time limit's too stringent, like any other time limit in the rules, it can be extended on consent or by order. A third claimed advantage of oral discoveries is that you get the benefit of the other side's lawyer in drafting written discovery questions. The implication in saying this is that, that this is a relative advantage for oral discoveries, is that you won't like the other lawyer's help when he drafts written discovery questions. But I think this is this issue goes both ways as well. Depending upon the personality of the opposing counsel, you often get too much of his or her help at oral discoveries anyway, and I think Joyce has talked about that. What people mostly fear about written discoveries is that they won't get evidence, but they'll get something that's contrived by the opposing lawyer. And there is some risk of this happening, but I suggest that if a lawyer sits down and just contrives answers to written discovery questions, he's running a much greater risk than examining counsel is running. There's an element of deliberation in delivering written answers that is absent from oral questions and answers. Information or belief that a witness gives in an oral examination can turn out to be wrong and be corrected without necessarily impugning the credibility of the witness or the party who got it wrong. And if the witness blurts out something, and it's not something that he personally was involved in, but he gives you some wrong information, it can be corrected, and in fact, under the rules, ought to be corrected, but it doesn't destroy his credibility necessarily, nor his party's. But on the other side of the issue, if you look at incorrect answers to written discovery questions, the incorrectness or the falsity suggests that there's either a deliberate desire to mislead, indifference about the truth, or confusion about what it's all about. I mean, there's not much else can explain why some lawyer and his client, having had the opportunity to get the right answer and then swear it under oath, sends you something that's wrong. It's got to be one of these three things. And I think on a crucial issue, even the last of them, confusion about the truth of what really happened, can be damaging to the other side's credibility, to the credibility of the whole case, not just to the witness. Because of the deliberation that's involved in preparing and delivering written discovery questions, in the jurisdictions that already have written interrogatories, they're treated as formal admissions. Now, I've stuck my neck out in saying that because I'm far too general. I'm not sure of every jurisdiction. I'm advised that that is so in United States District Federal Court practice, and I've read cases that indicate that is so in England. In other words, it's a formal admission, like an admission in a pleading. Now, the quality of formal admissions is that they can only be withdrawn in the circumstances that you've heard described this morning, on consent or by order of the court, and the court has to be satisfied by evidence that the admission was inadvertently made, that the solicitor was wrongly instructed, that the withdrawal will not cause any injustice that can't be remedied by costs, and that the fact admitted is probably wrong, or at least the question of the correctness of that fact raises a triable issue. Now, in other words, if you start giving wrong information on written discoveries, you may very well be digging yourself into a formal admission and have an awful lot of trouble digging yourself out. That's why I think you can send written discovery questions with a certain amount of composure about the fact that you're going to get something responsive. A written discovery answer that covers up the existence of inconvenient facts exposes the people who put it forward, counsel, the party, the witness, to quite another sort of risk. It's described quite succinctly in McCormick on Evidence under the heading Admissions by Conduct. In the chapter on admissions, McCormick, that's an American textbook, of course, there's something of the same in Wigmore, and both of them support what they say by copious reference to cases. Under the heading of admissions, they look at admissions by conduct, and under that heading, they look at misconduct in the course of the litigation, amounting to an obstruction of justice. And there's this statement in McCormick. We've seen in the preceding section that a party's failure to produce evidence when he's free to produce or withhold may be treated as an admission. As might be expected, wrongdoing by the party in connection with his case amounting to an obstruction of justice is also commonly regarded as an admission by conduct. By resorting to wrongful devices, he's said to give ground for believing that he thinks his case is weak and not to be won by fair means, etc. The point being that if you get what turns out to be a dishonest answer on a written discovery that was mulled over by the other side, thought about, and so forth, it feeds right into the theory of these cases. And McCormick goes on to say this: what's the probative value of these various kinds of spoliation admissions beyond their great tactical value in darkening the atmosphere of the party's case? They should, it seems, entitle the proponent at least to an instruction, and that obviously means an instruction to the jury, but it would apply equally in a case tried before a judge. An instruction that the adversary's conduct may be considered as tending to corroborate the proponent's case generally and as tending to discredit the adversary's case generally. I say, if the questioning party can find independent evidence for a fact that opposing counsels attempted to conceal by an untrue answer to written discovery questions, the deliberate proffering of the untrue evidence may itself become an admission by conduct of the fact that the party and the lawyer tried to conceal. And I say that trifling with the truth when answering written discovery questions is something that should commend itself only to people who, in addition to enjoying trifling with the truth, also like living very dangerously. And it's for these reasons I say that the concern that you're going to get junk when you ask written discovery questions is an overrated concern. Actually, what you get is directly proportional to the quality of the questions you ask. That's been my experience. In my view, a more serious risk than contrived, dishonest discovery answers is that the lawyer on the other side may find a weakness in your question and you get a junk answer. If that happens, you've got Rule 3304 to look at. Sub-Rule 1 says where the examining party is not satisfied with an answer, he may, within 10 days after receiving the answer, serve a further list of written questions. And Sub-Rule 2 provides in part that where the answer is insufficient, the court may order a further answer to the question. On a motion arising out of a further list under either of these rules, I think you're going to be more successful in your motion if your questions are carefully drafted. And I don't mean they've got to be intricate. Simplicity is the key. Now, in written discoveries, you've got to go right down the middle. On the one hand, you've got the incredible complexity that comes from trying to think of every possibility that you want to include in or exclude out. On the other side, you have a question that really doesn't ask the correct question and you get a junk answer. So you've got to go right down the middle, but you have to keep it simple so that it's intelligible, because there's no point drafting the question if nobody, even yourself after a few weeks or months, can't understand what it's all about. So the questions have to be simple. A further list of questions under Rule 35 is not confined to questions arising out of the answers to previous questions. That's the important thing to keep in mind. There's been one decided case on that. It's reported at 10 CPC, the Love and Mixing Equipment case. Master Donkin decided that the further list of questions has to relate to the subject matter. So, of course, in your first list of questions, you do have to lay out questions dealing with all the subject matter you want to discover about. But you're not confined in the way you are on a motion arising out of refusals, where the witness comes back and answers the question that's been ordered to be answered and questions properly arising out of the answers. In this further list situation, all you have to show is that the new list of questions relates to subject matter that has been dealt with previously but was not answered to your satisfaction. Now, your satisfaction as the examining counsel is not a subjective satisfaction. You have to demonstrate to the court that if you're dissatisfied with the answer, that your dissatisfaction is reasonable. And all that is laid down by Master Donkin in that case. So far, I've looked at the advantages and disadvantages with reference to the situation in which written advantages with respect to the situation where oral discoveries enjoy advantages. Now I'm going to look at the ones where the written discoveries do have obvious advantages. The first is where the witness is not easily available. If the witness is in Florida and it's going to be a short discovery and it's expensive, why bother bringing that witness up here if you can get the information in writing? If the witness is in jail, if the witness is in Timbuktu or whatever, if it's out the jurisdiction, in any of these situations, think seriously about written discoveries. In fact, if there's a motion to bring a client of yours from a long way away for what may turn out to be a relatively brief discovery, why not tender or cross the motion with an offer to submit to written discovery. Where the adverse party is a corporation, sometimes you just can't get at the witness who's got all the information. The witness who has the most personal knowledge about the situation may no longer be with the corporation. So that you know, even before you start, that if you get some witness in discovery there, you're going to have to question and question and question with the reporter recording them all. You'll get undertakings, and then either that witness will have to reattend and retail to you at second hand what other people told him or her, or you'll get it in writing. All this has all the disadvantages of written discoveries and none of the advantages. So where you think that you're going to run into that kind of situation, it may be as well at the outset to deal with written discoveries. Halfway down page 24, I point out the drawback to this discovery undertaking situation on oral discoveries. You see, the exact status of undertakings on oral discoveries is not perfectly clear, and there have been conflicting cases on exactly what the status is. In contrast, written discovery questions are clearly spelled out. Their status is right, they're explicitly under the rules. They're to be verified by, the answers are to be verified by affidavit of the question being examined. They can be read in a trial just like any other discoveries. There's a time limit for answering them, and it's a very stringent time limit, 15 days, but it can be extended like any other time limit under the rules. And as an example of this, if you're in a complex case and you know you can't expect the detailed kind of information you're asking within 15 days, it may be that a motion to a master to set an appropriate time limits in order. Master Sandler recently ordered that an extensive list of discovery questions were to be answered in 90 days, and that was done. Now, that's not something that you could get if you ask oral questions and get undertakings. It's very difficult to get the follow-up and get them answered because there's no rule that sets a time limit. There's no date on which people are in default that you can then go and complain that they haven't complied, and so on and so forth. There are hands-down advantages in this type of situation to the written discovery questions. I think written discovery questions are cheaper and faster. They're cheaper in the sense that the amount of time it takes to prepare oral discoveries and then conduct them is, if you try it yourself, you'll find no more than the length of time it takes to prepare the written questions and send them over to the other side. And the advantage, of course, is that you don't have to wait for weeks and sometimes months before the availability of the other counsel and his witness. On page 27, I put reference to something which I think is a very important advantage of written discoveries. Rule 3504 says, where the answer to a question is insufficient, the court may order the person to answer or give a further answer to the question. And it's been held in England that an answer to a written interrogatory is insufficient if it's qualified or couched in terms that make it useless. That's the kind of problem that Joyce Harris has mentioned in her talk about the contaminated answer. The McGeer witness who's so adroit that there's nothing you ever ask him that advances your case, because every answer he gives is colored by information that advances his case. And a court is frustrated in attempting to deal with that. Obviously, that's a form of discovery abuse, but a court is powerless to deal with it. Mr. Justice Salvi has held, well, witnesses will talk. Look what you can do on a written discovery. I've put in here a little illustration of the kind of problem Joyce was describing, where on oral discovery you ask, question, what's your full name? And the answer is, my name's Nathaniel Hawthorne, and the defendant promised to provide us with an effective, reliable, cost-effective time-sharing computer. And where do you live? Cape Cod, and the computer was not effective, etc. I mean, we've all seen that. Garth McGeer is a little bit more adroit at it than that, but that's the problem that people are dealing with. The technique of preventing the use by the other side of the discovery is I think, a prevalent problem with adroit witnesses. But you can't control it in oral discoveries. You can't tell a man that when he answers a question, he's to say nothing but what's responsive, because he'll sit down and say just the same sorts of things again and smile sweetly if that's what's needed. But in the written case, he can actually be ordered, the other side can be ordered to come back with another answer, and you can look at it, and it either is or is not responsive and non-contaminated. And there's an advantage. Rule 3503 requires that your objection to answering written questions has to be in the affidavit of the person answering. And this, in theory, should reduce motion time on written discoveries, because there's the considered objection. The court ought to be able to rule on it simply on the basis there's the objection. In the written case, you have that advantage. In the oral case, you're supposed to state your objection on the record, but since you don't have the chance to consider the matter at any length, the court has to give you more latitude on an argument of the motion as to what the objection is. And I think that that is an advantage to written discovery questions, although it's a theoretical advantage. In the remainder of my paper, I deal with advantages that I think written discoveries have for the judicial process as a whole. Time won't permit me to read it. I commend it to you. Let me simply point out that the discovery abuse that you run into in oral discoveries can, in some circumstances, almost vitiate the value of discoveries for both sides. In a recent article on discovery abuse, I read that in the United States, they have advocates who are well versed in the techniques of discovery abuse have two delightful words to use: pushing and tripping. Pushing is where you just go on asking more and more and more and more questions, perhaps until the witness dies of a heart attack. And tripping is where you just go on objecting and objecting and objecting until perhaps the other side's counsel dies of a heart attack. But those kinds of problems, the court has trouble controlling, because the relevance of questions, the more you try to keep discoveries down to what's relevant, the more you're going to run into permissible disagreements that result in objections and motions. The more latitude you allow to relevance, the longer these things are going to go on. Written discoveries have the advantage you can lay it all out. And where there is palpable discovery abuse, I suggest that the resolution of it may be to the benefit of all the parties and the court to be order that discovery proceed in writing.
I'll be dealing with production and examination for discovery of non-parties, and you'll find a short paper on the topic at pages M1 to M6 of your materials. First of all, why would you want to obtain production from a non-party? Well, you can find useful bits of information in these productions, and sometimes it may be the only source or a very important source of information. The bulk of the cases deal with clinical notes and records and other records of treating physicians, but I don't think we should restrict ourselves to that kind of document. It can be useful with respect to employment records, personnel files, the files of a disability insurer or of a no-fault insurer, as well as architectural plans, that sort of thing. The other thing to note is what is a document, and that's defined in 3001, and it includes recording, videotapes, that sort of thing. So you're not restricted to a paper kind of document. Well, when and how can you use it? With respect to production, you look at Rule 3010, and I've set it out in the materials, and it states that the court may order production for inspection of a document that is in the possession, control, or power of a non-party that is not privileged, where the court is satisfied that A, the document is relevant to a material issue in the action, and B, it would be unfair to require the moving party to proceed to trial without having discovery of the document. So it's a two-part test, and the rule is cumulative. In other words, you have to satisfy both sections, A and B. But as I state in the report, I can't think of a case where you wouldn't be able to prove B section of 3010 once you've proven A. Again, relevancy depends on the nature of the case. Just because a plaintiff sustains injuries in a motor vehicle accident, for example, doesn't mean that the entire pre-accident health history is open to scrutiny. And I think you'll find that what the courts are doing is they're restricting the time frame to a more reasonable time frame in the case law. In other words, instead of getting an OHIP summary covering 35 years, you may get an OHIP summary covering 3 or 4 years prior to the motor vehicle accident. So again, you have to look at the nature of the case and see whether it's relevant to obtain the document. For example, if someone isn't claiming lost income or wage loss, I don't know why income tax returns and employment records may be relevant unless it relates to, for example, the quantum of the claim. An interesting decision, it's not in my paper, that I read the other day was Hockenbow and Laskin, and that's found in 16 CPC 2nd edition. And in that case, it was a defamation action. The court ordered that a videotape be produced to a party. And the TV station argued that it was against the public interest for it to provide the party with the videotape. Apparently there had been a meeting and the alleged defamation had occurred there. And they used the in terrorem argument. In other words, once you allow the floodgates to open, everybody's going to want our TV tape. Well, the court held that you have to look at Rule 3010, and one of the grounds, once you establish A and B, is the document privileged. That TV tape was not privileged, and therefore the order went, and the videotape was ordered to be produced at the moving party's expense. There's two routes, really, to obtain production from documents. One is from non-parties. One is to use the direct approach using 3010. However, a number of cases support another route, and I'll call that the best efforts or the reasonable efforts approach. And most of the cases involve the discussion of the words possession, control, or power of the party making the request. And I think one of the leading cases is the Fedorzenko and Jameson decision. And that supports the view that there's an obligation upon a party to make reasonable efforts to obtain relevant documents from a third party, even if not legally entitled to do so, provided that there's some reasonable connection between the party asking the non-party for the information. In other words, you needn't use Rule 3010 in all cases. And I've cited a number of recent decisions which have supported that approach. And if I may just talk a bit about the Triumbari decision of Judge Koo. He felt bound by the High Court decision, which have held that the plaintiff has this obligation to obtain the information at discovery, or a party has this obligation. But he made this decision reluctantly, as in his view, one should use the route 3010, the direct route, rather than asking a party to obtain that information. Judge Koo set out a procedure for production of these documents. And basically what he said was it was responsibility of the plaintiff to examine the documents to see if they relate to the matter in action. And if they do relate, the counsel should prepare an affidavit, a supplementary affidavit of documents, and produce the documents. And the plaintiff can be obligated to reattend for further examination for discovery. If the defense is not satisfied with this approach or satisfied with the supplementary affidavit of documents, then you go via the route of 3010 for the direct approach. And again, this procedure has been followed in a number of decisions, I believe most of which are unreported, and I listed some of them in the paper on page 3. So therefore, there's two routes to get production, the direct route under 3010, or the route by asking a party at an examination for discovery to obtain that information. Besides production of documents, you may find that examination of non-parties is important to you, and you'll use Rule 3110 for this kind of procedure. And you can use the examination of non-parties, for example, where you're relying on an admission, and an insurance adjuster would have that information. You may want to obtain an examination for discovery of that adjuster in order to get it on the record. And it's also been used to examine witnesses to an accident, personal injury litigation. And even in a case where a witness provided a witness statement to one of the parties, certain further information was requested, they couldn't obtain it from any other source, Therefore, the court ordered in, I believe, the Wiseman decision that an examination for discovery of the witness could go. So Rule 3110 allows the court on terms to examine a non-party where there's reason to believe that information relevant to a material issue in the action, other than an expert engaged by or on behalf of a party, is involved, and it sets out 3 tests. Again, those tests are cumulative. You have to go and prove A, B, and C and satisfy the court that that's the situation. An interesting point is, if you look at Rule 3110(2) bracket subparagraph A, it says the moving party has been unable to obtain the information from other persons whom the moving party is entitled to examine for discovery, or from the person he seeks to examine. Well, it's been held in a couple of decisions that you have to establish both. In other words, you have to attempt to obtain the information from a party as well as the non-party. And B, again, I think that B would follow once you establish A, and C as well. You have to take a look, and that's whether the examination will unduly delay the commencement of the trial of the action, or entail unreasonable expense for other parties, or result in unfairness to the person being examined. There are cost consequences to using either of these procedures, and especially an examination for discovery of a non-party. So you have to make sure that the cost is worth it. You have to provide all parties who attend at the examination for discovery with a transcript free of charge unless the court orders otherwise. And with respect to what use can be made of an examination for discovery of a non-party, you have to take a look at 3110 subparagraph 5. And that specifically provides that the evidence of a non-party provided at discovery may not be read into evidence at trial under Rule 3111 subparagraph 1. So you can use the transcript to impeach credibility, for example, of a witness who appears on the stand, but you need the body. You can't just read in the transcript at the trial. And one of the most recent decisions that I was able to find is the decision of Mr. Justice Rosenberg in the College of Physicians and Surgeons versus Morris, and you'll find that set out on page 5. Basically what happened there was the college was attempting to restrict the conduct of a chiropractor, and it was alleged that the defendant was taking blood samples. And on discovery, counsel asked whether the witness had been asked to provide a sample of his blood, and his answer was, "I don't know." And plaintiff's counsel refused to undertake to learn about the information. The court found that the answers to those questions were relevant. It was not disputed that the defendant had been unable to obtain the information asked for on discovery.